Okay, Lauren and Brian, if you're ready, thank you everyone again for joining us. It is now 11 o'clock according to my clock. We are recording this and we've asked that you keep your microphones on mute throughout the presentation and use the chat feature to pose any questions you might have. Lauren, are you ready to take it away?
Yes, thanks, Eric. Good morning, everyone. My name is Lauren Brinjak, and I am the Senior Director of Government Affairs for the Pennsylvania Restaurant and Lodging Association. Thanks to everyone for being here. As you all are aware, changes to Pennsylvania's Minimum Wage Act regulations went into effect this summer on August 5th. These updated regulations make a number of changes regarding tipped employees. And over the last month or so, we've received questions from many of you about these changes. So we are happy to have with us here today an expert from the PA Department of Labor and Industry, Bryan Smolock, who is the Director of the Bureau of Labor Law Compliance, to go over these changes and also to answer your questions. Bryan, thanks so much for being here, and I'm happy to turn things over to you.
Lauren, very much. Thank you, Eric, for the reminder to everyone concerning the chat feature. I think a lot of people will be on this meeting today, so to keep it organized best we can, we'll use that chat feature. Happy to answer any questions you have. Happy to do our best to be as responsive as we need to be. I might very well have spoken to many of you throughout the last few weeks or month or two, actually, in the buildup and anticipation to these regulations. I may know some names on here. We would certainly say to you all, it's been a very busy time for our department as we have experienced a pretty big influx of questions, as you could imagine. A lot of people from restaurant workers all the way to restaurant managers and owners have been calling us for details about these issues, about these regulations. So I think this is a good opportunity today for us to start from the basics and work and build from there, get into the weeds a bit, and hopefully answer as many questions as we can for all of you out there. So let's begin. I'm Bryan Smolock. I am the Director of the Bureau of Labor Law Compliance. Our department is comprised of a number of different offices. Our bureau is, we call small but mighty, about 30 people strong, an investigative staff in 5 different offices throughout the state. We'll get to that in this slideshow. Near the end, I'll give you some contact information about how you can get in touch with us about any other questions of what you might have. So let's begin. All right, perfect. I have to use this slide. Technology is always interesting. I have to figure out what screen I'm using to go to the next slide. So our agenda here today will be presented as this, an introduction, some laws that we cover that may interest you that are not necessarily directly related to what we're here for today, but things you should be aware of, the new regulations, into the weeds, and then of course, questions and answers. So who are we? Let's set the groundwork first and discuss what labor law compliance is. A lot of text on that screen, but basically our bureau is comprised of what was once different agencies within the department. At one time, way back when, before I was born, and maybe before many of you were born, there was something called the Women and Children's Law. And the Women and Children's Law evolved to eventually become just the Child Labor Act. And eventually the evolution of that gave rise to different offices that covered only construction, and then some offices that covered only labor standards. Eventually in the 1990s, this was merged together. We became the Bureau of Labor Law Compliance, and we actually have the role of enforcing 13 different labor laws. Now, before we dive into the task at hand, I would like you to be aware of these labor laws as they relate to your businesses out there. We won't get into the weeds on these, but I will definitely tell you that if you have questions about them, let us know. Important things like child labor, wage payment and collection, medical pay, equal pay, personal file. They all affect your businesses in some form. Of course, the Minimum Wage Act is why we're here. But these other laws that we cover as well, I would urge you to be familiar with them and know the responsibilities of businesses under these different provisions. But back to why we're here today. Okay. The minimum wage law. So let me first, before I get into the, as we keep saying, the weeds on this, let me first inform everyone out there. In previous lives, I've worked in restaurants. I've actually done catering. For a very brief time, one weekend, I was a catering manager in which I was booking weddings. So I'm not going to say I'm an expert, as many of you on this meeting will be. You run businesses, I never ran one, as far as a restaurant at least. So I can completely understand the dynamics at play by being someone who has worked in a restaurant. Now that said, regulation-wise, we now have new responsibilities that we need to tell you about. This entire process has been an evolution since the regulations were proposed and since public comments were done and since we eventually got this approved by IRC. I can tell you that our office, me and other people within it, were dedicated to providing anyone out there with as much education as possible. There will always be an enforcement role for our department. There will always be times in which we have to investigate violations that occur and make corrective actions. But education, like we're doing today, is one of the most important things because it sets the ground, it sets the play, and it puts everyone on notice as to what the rules of that game is before we all play that game. So it's important for events like today to occur. And again, for the future, we're more than welcome to have other events like this. So the Pennsylvania Minimum Wage Act. So what is it? Well, number one, the tipped employee regulations that we're here for today fall under the Minimum Wage Act. You may sometimes hear people talk about overtime and people who should be paid overtime. That also falls under the Pennsylvania Minimum Wage Act. So don't be confused. When we talk about the Minimum Wage Act, it encompasses both minimum wage and overtime. And the Minimum Wage Act itself also includes the changes that have now been made to the tip regulations. Those new regulations, by the way, took effect August 5th. So we are now 1 month and 2 days into it. So we're beyond 30 days of the new regs. Again, it's been a busy time for us. I'm sure for all of you out there adjusting to these regulations too. Perhaps some of you have had to have made major changes and maybe some not so much. What do these tipped employee regulations do? So I'm sure a lot of you by now are familiar with these. Let's go back and rehash what the major changes were. Okay. So let's start here. To be a tipped employee, right? The regulation changes that we have done actually clarifies what a tipped employee could be considered. So federally, across the entire United States, to be considered a tipped employee under federal law, you must, of course, be considered who's someone in the industry making tips, right? Getting gratuity for the work you do. And you also must make at least $30 a month in tips. But what Pennsylvania did is different. What Pennsylvania did was, as of August 5th, the server now must make at least $135 in tips as opposed to the $30. It sets a higher standard. Sometimes people will be a little confused as to the idea of standards, and when there's one regulation under federal law that says this and a regulation under state law that says that, you would go with what's called the highest standard. And that means the law that's most beneficial to the worker. Reason being is because you don't want to get yourself involved with a situation in which you're in violation under the federal government, but not the state, because you would still be in violation, right? So you go with the highest standard of what is most beneficial to the employee in that circumstance. In Pennsylvania, $135 a month to be a tipped employee is the higher standard. So in Pennsylvania, for your restaurants, that will be what you must now judge someone's tipped employee status on, not 30, but 135, okay? This regulation clarifies that the employer can only take the tip credit, which is as low as $2.83 an hour, okay? You can only take the tip credit for those employees who make $135 a month in tips. One other caveat to point out on the difference between standards, don't forget, the federal standard is now lower, not only on the number of dollars you must make a month to be a tipped employee, but also the tip credit itself. Under federal law, it's $2.13 per hour. Pennsylvania has been higher than that for many, many years. Our base for the tip credit is $2.83 per hour. So remember that, again, $2.83 is the tip credit, but to qualify, the tipped employees that you employ must make at least $135 a month in those tips. A lot of you already know this, but we're going to rehash it for those who don't, and just for my personal edification to rehash it for myself. How does this tipped employee wage work anyway, right? So what an employer must do. Always remember that in some form or another, an employer must make certain that the employees are making at least $7.25 an hour. Now, you can pay the lower reduced $2.83 per hour when the person receives tips if they qualify. In this circumstance, again, to be a tipped employee, we're talking about the base now, $135 a month in tips. So when that worker makes that much in tips that month, you can pay the reduced rate of $2.83 an hour for the hours worked. You must still make sure that when tips and the $2.83 are coupled together on a weekly basis, that the worker is averaging at least $7.25 per hour. So the employee will report the tips of what they've made. You must make certain accounting wise that that worker is making $7.25 for when it's all said and done each week. So $2.83 is perfectly fine. $7.25 is also what needs to be somehow met when you combine those tips and the $2.83 together in the form of a wage. But we do something different as well under these new regulations. Now, let me first say, during our regulatory process and during our public comment period, it seemed like the idea of the 80-20 rule, which is what we've adopted, was somewhat industry standard already, right? There's been some confusion at the federal level. It seems like that confusion is settled. The dust is settled. Pennsylvania now is basically aligning itself better with federal regulation. We believe that that's important because it sets the ground game perfectly for your restaurants and your association. You would know now, all right, federal law is 80-20, state law now aligns with federal law 80-20. We got the same standards. We're not going to worry about two different standards, two different divergent standards, right? So the long followed standard of 80-20 is now codified into regulation as of August 5th as well. That regulation permits an employee to be a tipped employee as long as said employee does not work more than 20% of a 7-day work week previously established doing duties that do not directly generate tips. All right, let's unpack that. Let's first talk about the 7-day period of time. Under the Minimum Wage Act, a work week is able to be defined by the employer. The work week, however, should not be constantly changing, right? An employer can't say, well, your work week this week starts on a Monday, but next week starts on a Tuesday, and the week after back to Monday. It needs to be consistent. Employees need to be aware of what their work week is. And that 7-day period of time as defined by the employer could be different for your business in this city versus that city. But you need to define it, and it needs to be standardized and consistent. So now once you've defined what your work week is, as employees clock in and clock out, any work during that work week, number one, needs to be tracked properly because you might have to pay overtime. And number two, now needs to be tracked properly because of the 80-20 rule. Let's get into this more. We're going to give you some examples of what 80-20 really means practically speaking, okay? And then we're going to show you a listing of what different jobs might be considered to be one that is a tipped employee work versus one that's not. And for those out there who have talked to me before, again, maybe I've even talked about these examples to you before, but let's go through them again anyway, all right? For the sake of these examples, let's say that these workers are making $2.83 an hour, okay? So the employer has opted to pay them the tip credit wage in these examples. We're gonna start with Sally. Sally's a server at a restaurant, and she earns $2.83 an hour, regardless of the work that she performs. That's important to remember. So Sally normally works about 35 hours a work week or 5 hours a day. In this example, in the previous 4 weeks, the kitchen staff has been short. I'm sure all of you out there, from what I hear about things, that's probably not a surprise to hear that there might be a short staffing issue. Sally has been working 2 hours daily doing dishes. She's helping prep and cook meals, and she's cleaning facilities, right? Then for the other 3 hours, she's doing her server duties. Now, the employer is paying Sally $2.83 an hour for all of this work. And at week's end, she works 21 hours doing server duties and 14 hours doing kitchen duties. So Sally now at this point has lost that ability to be paid $2.83 an hour for the work involving that 20%. She's being paid not in compliance with the 80-20 rule. In this example, since Sally is working more than 20% of the work week, the $2.83 an hour for those hours should not be paid that way. That would be incorrect for the employer. The employer must now pay $7.25 an hour for the work involving anything that is not tip related. In example 2, Bob's a bartender. Now we're going to say Bob makes $4 per hour. Again, he's a tipped employee. Perfectly fine. $4 an hour is perfectly fine because Bob is making tips as he waits on people. In this example, he's been working for about 40 hours a work week, and he's been told that he needs to clean the facilities and mop the kitchen floor. And that for basically will be about a half hour each day. By week's end, Bob will have worked 3.5 hours doing non-tip work, but he's in compliance with 80-20 because not more than 20% of the work is beyond, which is why Bob can now be made Bob can make $2.83 an hour. What does this 80-20 rule now really mean when it comes to tip producing work? So duties that directly generate tips, right? But they're not limited to, as we say here, just taking orders, serving food and drinks, or preparing drinks. It's duties that need to be actually directly done to get tips into a server's pocket, right? That's what a tip producing job would be. Duties that don't directly generate tips, but are directly related to that could include, as we say here, wrapping silverware, refilling napkin holders, tasks that might be done by certain people in the restaurant that are not servers, maybe a bus person, right? It could be a duty that directly is related to those duties, but is not directly one that generates the tips. And then finally, what is not at all generating tips, that would be people who are cleaning, people who are taking inventory, ordering supplies, scheduling, things of that nature, right? They don't at all deal with any tip producing work at all. They should be factored out. That is right. It should not be considered to be generating tips at all when you're not doing any work. A kitchen staff person, a dishwasher, again, someone who's doing the inventory in the restaurant, someone who cleans the bathrooms for many hours. Those are not tip producing jobs. So the employer can take the tip credit for the time the tipped employee spends performing directly supporting tip producing work, provided that the employee does not perform that work for more than 20% of their work week. Okay, so let's think about another example, and I don't have this on screen. Let's say you work for 5 hours today. But no, let's say you work for 10 hours today. You only work one day this week, 10 hours, okay? As a matter of fact, you only work for one day this entire month. Let's make it really simple. I'm an employee for one day this entire month, and I make $200 in tips, so I'm fine. Number one, I'm good. I made my $135 already. I could be now paid $2.83 an hour, okay? So of my 10 hours this week, the employer tells me, listen, Brian, for 5 hours, we're gonna pay you $7.25 an hour, and you're going to be a dishwasher. Okay, good. I'm being paid $7.25 an hour for non-tip producing work, and it's for 5 hours. Now we have 5 hours remaining. Of those 5 hours remaining, I do 3 hours, right, of tip producing work. I'm a server for 3 hours that day. And then for 2 hours, I do other tasks which are supporting tip producing work. Okay. So 80-20, let's go back to that. In the 80-20 example, you eliminate the 5 hours when you're in the kitchen because the employer has opted to pay me $7.25 an hour, which is proper. It's taken out of this equation because we have a dual job situation. And federally, that's the way it's done as well. But for the server hours, for these 5 additional hours that day, remember, they can only claim the tip credit, okay, if that tip producing or directly supporting work falls into the 80-20. In this circumstance, it does not, because when we do the calculation, clearly 80-20 of those 5 hours, now they must pay me a higher rate if I don't meet the 80-20 for my one day that month. I hope that makes sense, and we can certainly come back to this again I do think there's going to be some additional questions as we go on. So not a problem to ask those questions at the end. This next slide you're seeing on your screen now, it's very information heavy. As a matter of fact, this slide, and this slide are very information heavy. I'm not necessarily going to read you these slides. Where do you find this information? Simple. On our website, under, and we'll give the link at the end, there's a section specific for these new regulations and for anything related to them, including frequently asked questions. I actually copied and pasted 3 of those frequently asked questions. We have been constantly trying to include more information on our FAQs based off of questions we get. And these actually were done in response to many questions that we've received. Perhaps someone on the call on this meeting today even was involved with asking a few of these questions. So these are, as you see on here, tip producing jobs. We're talking servers. A lot of this is logical. A lot of this is common sense. Servers, bartenders. Of course, we go beyond just the restaurant world. We're talking about nail technicians, talking about hotel bellhops. Because remember, even though the world you're in for you might be a restaurant world, tipped employees could be far ranging beyond just restaurants, right? So we wanted to include the tip producing jobs that we felt were very black and white, and there they are. We also wanted to include jobs that are that support tip producing work. As again, you can see here, that server who vacuums the dining room or fills salt and pepper shakers, folds napkins, right? That could be a part of tip producing work. Perhaps in this circumstance, a parking attendant. Directly supporting work includes cleaning the valet stand and parking area, right? That could be factored in for 80/20. Here, of course, is what's not tip producing work: prepping food, cleaning those bathrooms, ordering those supplies, cleaning non-residential parts of a hotel, right? Those things are not tip producing work because you're not dealing with anything in which that money is going into your pocket. Okay. And before I move on, remember, I'm going to rehash this again as we move forward. You can find any of this information on our website, and these questions specifically are on there. So absolutely go to there, find the information you need. And if you don't find the information you need, call me up, email me, we'll research it. Okay, moving from 80/20, we also have some other significant changes that you need to know about. One of the most, actually, I would say, popular issue of phone calls and comments that we received both before and after the regulatory process was over was about credit card transactions. So in this circumstance, in these regulations, we are stating that an employer cannot take money from someone's tips for the credit card transaction fee. We have been told in some instances it was very commonplace to have this done. Other people we've talked to said, no, we as a restaurant, we've decided not to do this and never did. Federally, it could be done. Federally, actually, under some rules, you can actually take from the credit card tip itself. But in Pennsylvania, we were saying, no, you cannot do that. The tip that someone earns is their tip. And we have an example written onto this slide. Basically, this credit card transaction as it existed prior to August 5th would allow the employer to deduct that transaction fee percentage from the worker's tip. In that example, the server receives a $20 credit card tip, and the fee to process that is 2%, and the employee is charged 40 cents. Therefore, instead of getting the full 20, they get less than 20, right? We're saying no. They must not receive only $19.60. They must receive the full credit card tip, and to take any money from that tip would actually be a violation. This new regulation makes this type of deduction improper. I have said before, arguably it may have been improper prior anyway, because under a different law, the wage payment and collection law, an employer cannot actually take money from someone's pay unless it meets 2 different criteria. Number 1, it must be beneficial to the employee for it to come out. And number 2, it must be signed off in writing, right? It really never existed. So in a sense, you could have almost viewed this type of deduction as improper before. But without this new codified regulation, it was not really as black and white and as coherent as it is now. But now it is. Now for sure, the credit card deduction cannot occur from that tip. It must be given in full to the worker involved. Service charges. Service charges is another regulatory change which actually addresses the bill itself that the customer receives. We all know what service charges are, but sometimes customers don't. And that's the rationale behind this regulatory change. Many times a customer would see service charge in a bill and not have any clue at all where it goes to, and perhaps incorrectly make the assumption that it's going to the workers involved with the service of that restaurant, and it may not have been. Our regulatory change now states that an employer, right, has basically a business. In this sense, it's a customer business relation as opposed to the worker business, but they must notify the customer of any charges for the administration of a banquet, a special function, a package deal, right? It's got to be a statement on the menu itself. It needs to be in a contract with the patron who's paying. And it's basically a notice to the customer. Okay, customer, you're going to pay this much for your wedding or your funeral or whatever the case may be. And this service charge that we're charging right here, it will be on the menu and in the actual bill itself that the patron realizes where that service charge is going. Basically, that's not going to the worker in the form of a tip. Okay. Now, of course, it could. You can give the service charge to the worker, but under federal rule currently, that cannot count as a tip. Remember that. So being that we're agreeing with some federal law here, we're also taking that section on as well. If you charge a service charge and give it to the workers as a tip, it doesn't count as a tip. It has to say gratuity, and it has to be from the customer to the worker for it to be a gratuity. Let's dive into the tip pool. Okay. So another significant change that we have done actually clarifies and codifies some already existing federal rule as well. So we don't necessarily feel that this is too earth-shattering, and it seems from the calls we have been getting from a lot of restaurants that this is already being adhered to, which is something we applaud. Now, of course, when it won't be, we would address those circumstances, but let's talk about what this tip pool regulation change does. Number one, contrary to many calls we are getting, it does not at all say that you must do a tip pool in your business. As a matter of fact, you have the ability to allow for a tip pooling process or not. You could have servers keep their own tips from their own tables, or bartenders keep the tips that they receive. There is absolutely no requirement that you tip pool. However, when you do tip pool, now there's ground rules, right? We always talk about this idea that now you're playing the game of tip pooling. When you play that game, here's the rules that you must adhere to play that game properly and win, right? So employers need to notify a tip worker of what the tip pooling arrangement of that establishment is, right? Workers need to be aware of what their duties are as a worker, whether it's them giving the tip pool or giving the tips over to the pool itself or putting those in their own pocket, right? They need to be aware of that. The employer must make them aware of that at time of hire, or even now as the regulations have changed, we would encourage you to constantly make them aware of this. It's probably not a bad practice to have staff meetings and really tell people to do that. Tip pools can include both traditionally tipped and non-tipped occupations, but there's exclusions for that. Let's get into those. Let's start first with who must be out of the pool, right? All right. So individuals with ownership or a partnership interest in that business should not be in the tip pool, right? An employee who meets all parts of the executive employee duties test, but not the salary requirements, must not be in the tip pool. We're gonna have a slide on that in one moment. So we're talking here who's out: owners, managers who are true executives hired to be a manager, any partners in that business, they must not be in the tip pool. Now, if they wait on some tables because things get busy, or work at the bar because things get busy, they can contribute to the tip pool, but they cannot take money from the tip pool, okay? And again, this is when we tip pool. If you don't tip pool at all, and the manager goes and waits behind the bar for customers because it's so busy on the floor, and for 2 hours the manager's earning tips, if there is no tip pool there, we're not saying the manager can't have that money and report it as income. We're not saying that. We're saying when there's a tip pool that people are putting in money, that's when the manager, executive, partner, owner cannot take from that tip pool. If the employer takes a tip credit, here's the important thing, tip credit 283. If the employer is paying people 283, it must exclude any employees, right, who don't spend at least 80% of their daily work. So we're talking the 80-20, must exclude people who are not performing tipped work if they pay people in the tip pool 283 an hour. If they pay everyone in the tip pool above the minimum wage, right, different story, which we're going to talk about in, I thought we had a slide on that. Maybe I didn't. So without that slide, let me explain the difference. I'm going to put it very simple. If I have a restaurant and I pay all of my servers $283 an hour, and all of my kitchen staff are making at least minimum wage of $725, and I have a tip pool, I am not able to give any of that tip pool money to the back of the house. Reason being is because I'm paying the servers $283 an hour. If I'm paying everyone 15, 16, 17 bucks an hour and we tip pool, it could be shared with back of the house as well. Again, it doesn't have to be. The rules of this tip pool would be the employer's rules. Our office and our new regulations are not stating that a tip pool needs to be done. It just sets the ground rules of who needs to be out of the tip pool when you're taking a tip credit. And it definitely, no matter what, even if you have everyone being paid $725 an hour, it should never include the owner, the partner, or the manager. They would be always out of the tip pool. What is a manager? Great question. I'm sure someone might be thinking that. So you can call someone a manager, but maybe they don't manage, right? And perhaps the manager title could be done to elevate someone within your business, but they don't actually meet the executive duties test. Here's what the executive duties test is. Now, remember one important thing. There's one portion of the executive duties test to be a true manager under federal law. If you're a salaried manager, there's a minimum salaried requirement, dollar-wise, of what you need to make. But our regulations have adopted federal law without that salary requirement within. So instead, our regulatory change only looks to the actual duties test instead of the dollar figure test. It's a very important distinction. So now a manager under the regulations that we currently have in place is someone whose duty is primarily the management of that enterprise. So basically someone who is hired to be the manager, right? It's a manager. It's someone who customarily regularly directs the work of 2 or more people, and someone importantly here who has the authority to hire and fire, suggest who should be hired and firing, and they actually have a say in that suggestion. Someone who discusses the advancement or promotion or other status of people within that business. So we're not talking about someone who's a server, but also is that night put in charge of 2 new employees and telling them, here's the ropes of what you do. This is the way you wait on a table. Here's where you can find whatever. That's different. We're talking about someone whose duties management, someone who has been hired to be the manager, someone who meets this executive duties test. When they meet this test, you should, as a business owner out there, if you have an organization with managers, look at this duties test. If they meet this, they should not be in a tip pool. Pure and simple. By the way, and I put this slide in here because I just mentioned the salaried requirement dollar-wise. Our Pennsylvania regulations currently do not address the salary dollar figure requirement. So if you're going to talk, if you have any specific questions out there concerning who meets the criteria of a salaried exempt worker, I would highly encourage you to speak to the United States Department of Labor. They have set the ground, I believe it's 35,000 and some change concerning how much you must be paid to be truly a salaried manager. So it's important. Dollar figure wise, we can't discuss that with you. We don't have the regulation here, but the federal government does. But we do, again, back to this, we do adopt the duties test. So again, that manager in your business, eliminate the salary requirement. If that manager is doing any of that right there, and that's their primary duty, out of the pool. Fluctuating work week has also been affected. Now, what I quite frankly don't know is how many out there are overly interested in this topic. I believe a lot of what we've heard from through the process with the regulatory change came from more manufacturing as opposed to service economy roles. But we need to mention it because it's a very important change. What a fluctuating work week basically is this: someone who's a salaried worker, but they're not a manager, not a professional, and they don't meet the executive duties test at all, right? They could be paid a salary still. That's perfectly reasonable. What the fluctuating work week allows for is for the overtime rate to be based off of the hours of work each week. So if I'm a salaried worker and I only work 20 hours this week, I should still get my salary. But if I'm a salaried worker and I work more than 40 hours, I still have to get overtime because I'm not exempt. What the fluctuating work week allows for is me to divide my salary by the number of hours I worked. Therefore, my overtime rate will constantly change or fluctuate. It might be, 10 bucks this week, it might be 20 bucks next week, right? It all depends on the hours of work. What our fluctuating work week change has done, we've actually now said, no, here's the ground rule, back to the game. 40 hours of work, that's it. The work week is now based off of 40 hours. Anything over 40 should be time and a half. Now, again, I don't want to murky the waters because with this regulatory change, we've done a few different things, which are on this slide, we talk about fluctuating work week, but we've also done a lot of number of things on tipped employees. So don't be too confused. Again, a fluctuating work week change is for someone who's a salaried worker who's being paid on a salary, but does not meet any of the duties that they need to have to be exempt from overtime. We're saying for those salaried workers, 40 hours a week is that number. The magic number is 40. Anything over 40 now is time and a half after that, similar to what currently exists, by the way, for hourly workers. Okay, boy, time goes fast. I want to have time for questions. Let me just really briefly talk about a couple other things without going into major detail. Wage payment and collection law. You can read this slide yourself, but basically it's this: if someone works for you, you must pay them. Pure and simple. If that worker does not get paid, or if you are upset with that worker because that worker damaged something or messed something up or really screwed up an order, whatever the case may be, and you terminate their position, which by the way, you can do, it's an at-will state. You have to pay them for all the work that they've done, right? And when a worker is not paid, they actually have grounds to file a complaint against the business. So a lot of the claims we deal with are these types of cases where a worker is in a dispute with the employer and for some reason or another, they have not been paid. So please understand your role in this is to make sure workers are paid on a regular pay date for all hours that they have worked. I also have a slide in here for child labor, and I put this slide in here again. We've made no regulatory change on child labor either, right? But I would like everyone to be fully aware of it. I think maybe yesterday you may have seen the press release from the federal government of a number of different businesses in the middle part of the state having violations for child labor. In Pennsylvania, we also enforce and regulate child labor, and we have seen a remarkable increase in reports of violations happening and violations that we're finding. I get it. A lot of issues are happening with the workforce. A lot of people are telling us that people can't really find the pool of applicants necessary, but child labor itself, we have rules in place and they've been in place for decades upon decades for a reason. There's prohibited occupations of what kids can't do. As a matter of fact, if you hire a child, we have a list of prohibited occupations on our website, as our lady in red is giving the thumbs down. A good example for you in a restaurant, let's be sure that you're not doing something where a child using a meat slicer until the age of 18. That's improper. Let's be sure that in your restaurant, if you serve alcohol, that you're not having a 16 or 17-year-old do it. That's against the law. As a matter of fact, if you have a liquor license, you should not even have anyone under the age of 16 working there. So I don't want to get in the weeds on child labor, but I want you to be aware that the child labor law itself exists. It's there for a reason. Please pay attention to it. We've seen, again, an increase in different types of violations that are actually happening throughout the state. I will briefly touch on this because it's important for you to know. If there are complaints from workers that you employ or any workers in general that file claims with us, we in our department, we address those complaints typically on a case-by-case basis. Sometimes they might trigger a larger look at the overall establishment if there's a practice that might not be proper. Yes, the bad news is we come and call you up and we say to you, this is what the law is, and if you don't adhere to it, here's what the penalties might be, and here's what the court action might be, and all that bad news. But a part of this as well is we're educating you, and we would like you to come into compliance. If we discover a violation's happening, our role in here is not to just punish. That's not really what we're here for. Our role is to make sure that you correct the actions of what's occurring and that we come into compliance and we don't have further issues. Yes, there are employers or businesses out there that sometimes ignore us and shrug their shoulders and not care. They're the ones that could now go into a more formalized court process. That thankfully is the minority of businesses that we deal with. For the most part, we find a lot of places to be very responsive to us, and we appreciate that. But a part of this entire process of these regulations, there's got to be an enforcement mechanism behind it. That's what we're here also for, not just education. But when someone does not adhere to what we're stating the rule of the land would be now, that does become a problem that we have to have corrected. And if it's not corrected, we're forced by law to take that action further to court. So that's the negative part of this presentation. We won't dwell on it. Workers can file claims both in English and Spanish. They can do so on our website. And let me just say, under the resolutions to these complaints, again, typically we might have a larger audit depending on the possible violation. But an audit doesn't necessarily mean a violation. Always remember that. When we call you or when we write you a letter asking for information, it's to investigate these things. When a complaint's filed, the complaint could be wrong. The complaint could be maybe the worker is owed money, but they're not owed what they say they're owed, right? Maybe there's not as many overtime violations that they might report to us. Our office's investigation process is meant to uncover those things, and we try to conclude whether the worker who filed a claim is right or wrong, and then correct actions at that point with you. So, fast forward to the end game of our slideshow. Only a few more to go before I do see a lot of questions may have come in. So I'll have to read. I didn't read them yet. I'm not that talented, so I'll have to read them as we go. But anyway, our website includes a lot of information. We are constantly evaluating what's on there. And when good suggestions come in and new frequently asked questions come in, we add those. So please review it. And if you're not finding what you're looking for, call us up, email us, right? We'll work with you. And if it's something that we need to address in writing on our site, we'll make that go through the process to try to get something on there. So you can find all information of what we're talking about today, including these FAQs, including those duties of what's under the 80/20 allowances at www.dli.pa.gov/overtime. Sometimes our website's pretty tough to navigate, but that link will take you directly to where you need to go for everything we're talking about today. Also, posters. So we have free posters, and we just actually updated and changed our minimum wage poster based off of the new regulatory change. You all out there might get people who send you things in the mail stating that you must buy these posters, and if you don't, you're going to be subject to massive fines. You can buy them if you want to, but if you're buying them, it's not coming from us. Buyer beware, right? It's like the service charge. Buyer beware. Those poster companies are not us. As a matter of fact, anything that the government puts out information-wise and anything the government has regulatory-wise, remember, we don't copyright it. It's free information for you. All of the posters that we have are all for free. You can laminate them and make them beautiful, whatever you would like to do. But either way, as long as you have these posters up, even if they're on paper, that's perfectly fine. You're in compliance by doing that. Buy if you want, print if you dare. You can contact us at any time. Now, here's where our website, or our link rather, gets a little tough. I really wish we had an easier email address to remember. It's not that easy to remember, right? So if you're looking at this slideshow right now and you're feverishly trying to figure out that email, let me just read it to you. I know this is being recorded, so you can go back and hear it again. ra-li-slmr-llc@pa.gov. That's a mouthful, and I apologize for that long email address, but it's the way our state system operates, unfortunately. So finally, as we close out our slideshow, we are located in Harrisburg. We also have 4 other district offices statewide in Altoona, Scranton, Pittsburgh, and Philadelphia. And I believe this PowerPoint presentation is in the hands of Lauren, and I'm assuming Lauren can get that out to anyone who's on here today. So if you don't have the ability to see that or write it down, I believe we'll be able to get you this slideshow. And then my last slide is a thank you. And I do thank you for allowing me to share my screen and allowing me to now stop sharing my screen. Lauren, I'll simply say one more time, as you send that PowerPoint around, my information's in there. So absolutely, people can feel free to call me with more questions. I hope this helped today.
Great, thank you so much, Brian. I'm sure this was definitely helpful to our members. We will make this presentation available. And if anyone has any questions, like Brian, definitely contact Brian or send your questions to me and I can get it over to Brian as well. But thank you, everyone.
All right. Thank you, everyone. Have a nice day.
Thank you.